base to reach out to the sheriff's department about whether or not there are additional videos that exist. And he did so, and he's informed that they do not exist.
Okay.
I think Ms. Bozzi can maybe articulate it more as to why she thinks that there should have been, or why she has questions about it. But nevertheless, I suggested to her that, you know, by all means, she could set it for a hearing. She can issue a subpoena for the officers. I certainly will do whatever I need to do to facilitate that if that's what she chose to do.
Yes,
Okay.
Your in the police report, the officer that pulled over Mr. Calvin stated that she uploaded a body cam footage and dash cam footage, and that was nowhere in scope.
Okay.
So that was our concern.
Sure. But it sounds like whatever they did with it, it's not there now, unfortunately.
Yes, Your Honor. I don't know what happened with it. So.
Okay. All right. Thank y'all for putting that on the record. And, but you want to go forward with the plea today. Is that correct?
Yeah.
And are we going on count one only?
That's correct. Just the state would abandon one of those enhancement paragraphs or punishment
Both of the,
enhancement paragraphs.
okay. All right. So Mr. Hawkins, in cause number 24, DCCR 1160, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of unlawful possession of a firearm by a felon from January 31st of 2024. And how do you plead to that charge?
No contest.
It's guilty or not guilty? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Bosley? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1, any objection?
No.
It's admitted. Is there any evidence that Mr. Hawkins is not competent?
He's competent, that's my knowledge.
Thank you. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Bosley. All right, good luck to you, sir. You can go back with the bailiff. And Mr. Coleman, would you mind helping out with that attachment?
Yeah, in fact, I'll that.
Good morning. Are you Caleb LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
So this is the one. So it's not a first.
No, we amended the indictment to 3rd degree.
I didn't write that at the top for some reason, but I see I wrote it in. All right, Mr. LaFleur, in cause number 26, DCCR 0039, you're charged with a 3rd degree felony offense of theft of property. And that is from December 14th of 2025. And how do you plead to that charge?
From December 14th.
November, did I say December?
Yeah,
Sorry, November 14th of 2025.
yes, ma'am.
Are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. LaFleur is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of theft of property. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition, then your bond would be raised and you would have to go back to jail, right? Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games. Morning. Are you Nir Brown?
I'm not here today on special appearance.
I'm sorry. Speak up so I can hear you.
Here today
You're appearing here today.
by special appearance.
Okay. What is your name?
I'm a third party intervener on behalf of an artificial legal entity, not Nir Brown.
Okay. At one point in your,
Again, don't talk about the chamber of
at some point in your life prior to being this third party, were you Nir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative. That's it.
So are you Nir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said because you have now identified yourself as Nir Lewis Brown. And so, Mr. Brown, this is your initial appearance and you have 2 cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
It's been up and down.
Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it
They
again.
overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out your bond would be raised and you would go back to jail. Do you understand that as well? You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk.
At this point, the courtroom dynamic completely changes. The judge isn't arguing the facts of the case. More, she's trying to determine whether Mr. Brown actually understands the court's orders. Phrases like "I overstand" and repeated jurisdiction challenges may sound strategic. But in a courtroom, judges care about one thing. Can the defendant clearly understand and comply with the law? And here's the real question for you. Do you think Mr. Brown is making a legal argument? Or is he accidentally making his situation much worse? Because every answer from this point forward seems to push the court's patience closer to its breaking point.
What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the cop. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your two cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is foreign age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you,
Why would you lay hands on me?
because you're not doing what I'm telling you. Now go. She's
Mr.
telling
Brown,
you that she'd go
you
back.
need to go back with the bailiff. Right now, I've raised your bonds. You have